Hi, I'm Neil Milton. I want to talk very briefly about will challenges in Ontario. Ontario is a very difficult jurisdiction to challenge a properly drafted and prepared will in. It's very different, for instance, from British Columbia. So in Ontario, the grounds for challenge usually relate to whether the testator lacked capacity to make the will. That's a fairly low bar. And also whether they were susceptible to undue influence from a beneficiary. It's very, very fact dependent. These cases, they're very difficult. They're often quite expensive. And you really need to know going in that you have some reasonable prospects of success. And that is best done by having medical evidence early and upfront. So not to engage in a fishing expedition or a mudslinging expedition about your sibling. It's to know from the doctors what your parents' mental status was around the time of when they made the will. So they are difficult, they're expensive. And lastly, it's important to realize that many cases that people think of as will challenges can be resolved in much easier, faster means. So there are other things like dependent support claims that are an alternative to a will challenge. We've done many of them. They are quicker, faster, cheaper, and better in all respects than a frontal attack on the will. So if you have questions, please send us an email. We'll get right back to you.